Hello everyone, welcome and thank you for joining our webinar, Observations from the Frontline, Current Themes for Due Diligence in Australian Mid-Market Transactions, presented in partnership between the Legal 500 and Kane Lawyers, the Australia-based legal consulting company. My name is Alan Cohen. I am a research editor at the Legal 500. And well, before I hand over the webinar to our impressive panel, I'll give a brief introduction of today's topic. So this webinar brings together transaction specialists and deal technology and intangible asset experts to highlight, as the title suggests, the key themes which arise in due diligence exercises for mid-market Australian transactions. We will be discussing the technologies and legal understanding required to mitigate the risk and deliver value to purchasers, such as foreign investment approvals, intellectual property, privacy, use of platforms for transaction management and due diligence review, and the main mitigators of risk. But first, let me introduce Jerry Coulson, who will moderate and lead us through the discussion. Jerry, I don't know if you want to say a quick hi so everybody sees you.
Hello, everyone.
Hi. So Jerry's a lawyer with over 30 years of experience advising in capital raising transactions, M&A, and capital structuring across key financial markets, in particular in Sydney, of course, Hong Kong and London. He's the trusted advisor to many clients, helping them buy and sell businesses, raise private equity, list on stock exchanges, and negotiate joint ventures. He's also an experienced board director, and he's frequently called upon to provide expert commentary around many trends in the mid-market. And in fact, Jerry's regularly named Lawyer of the Year in the fields of M&A and private equity, and he was named a recommended lawyer in our Legal 500 2022 Asia Pacific edition in corporate M&A. So I'll hand over to our panelists in a moment, but before that, I would like to let our audience know that this session is interactive. So if you have any questions at any point during the webinar, please submit them using the Q&A function at the bottom of your screen, and we will put them to the panel once the presentation is over. Okay then, Jerry, so I'm handing this over to you now. Feel free to introduce the topic further, Kane Lawyers, and really just lead the conversations and get us on the way.
Wonderful. Thank you very much, Alan. Good afternoon, everybody. Good morning if you're in that time zone. Thanks for joining us today. I'm delighted to be able to introduce today's session, which will provide some observations from the front line on current themes that we're seeing for due diligence in Australian mid-market transactions. After a short keynote presentation from my colleague Elise Rashadi, we'll hear from Michael Masterson, who's the Managing Director of Everedge Global, which is an intangible asset advisory business, and Tim Strawn, who's Head of Sales for Asia for Ansarada, a technology solution company that has a focus on improving the efficiency of due diligence processes. As Alan said, I'm Jerry Coulson. I'm a director at Kane Lawyers. Kane Lawyers are transaction specialists. We specialize solely on mid-market transactions, private and public mergers and acquisitions, equity and debt raisings, capital structuring, and transaction disputes. We're honored to have been recognized by Legal 500 as one of the leading corporate and M&A firms in Australia. Kane Lawyers is a bit different from your typical corporate firm as a result of our hands-on approach that our directors bring to our transactions. An independent offering focused on transactional work, working more with your incumbent commercial and specialist lawyers than seeking to bring in our own expertise for areas where we don't focus. An efficiency in execution as a result of our deep understanding of mid-market transactions, and I'm pleased to say top-tier expertise, with many of our lawyers having trained at top-tier firms in global capital markets. Elise Rashadi, who is a director in our corporate transactions team, is one such lawyer. Elise specializes in private and public mergers, acquisitions, and capital raising. Prior to joining Kane Lawyers, Elise worked at Slaughter and May in London and at Ashurst in Melbourne and Adelaide. Elise has acted for a number of ASX blue chip companies, as well as a number of FTSE 250 listed companies, and has some insight of the challenges and opportunities faced by in-house counsel as a result of an extended secondment into the in-house team of Energy Australia during a significant transition of its corporate strategy. Elise is going to talk to us today about the current themes that we're seeing for due diligence in Australian mid-market transactions. So I'll hand over to Elise and get us underway.
Thanks very much, Jerry, and good afternoon or good morning, everyone. It's great to be here. I have a short presentation, so please bear with me as I share my screen.
We can see this, Alice. Thank you.
Wonderful, thank you. So today I'd like to focus on 5 areas of due diligence that we're seeing more commonly in Australian mid-market transactions. And those are foreign acquisition approvals, privacy, IT and cybersecurity, intangible assets, and WII Insurance. Now, as the old adage goes, time kills deals, particularly as market uncertainty grows with inflationary pressures and a challenging geopolitical landscape. We're seeing these 5 areas of DD I just mentioned more commonly because there are particular areas of risks associated with them, and these need to be identified early with enough time that the apportionment of risk can be negotiated between the buyer and seller. So starting off with foreign acquisition regulations. So in 2021, some of you may know that there were some changes made to the Foreign Acquisitions and Takeovers Act that we have here in Australia. And these were probably the most significant reforms that we've had to our foreign regulation regime since it was implemented in 1975. Among other things, they introduced the concept of national security powers. And broadly, there are 4 of these. 1, mandatory notifications of investments into national security sectors. 2, an ability for the Treasurer to call in investments, which he or she assesses as posing a national security risk. 3, the option for investors to extinguish this call-in power by making a voluntary notification. And 4, a last resort power for the Treasurer to review actions, even where it's given a no objections letter, where there's a national security risk that emerges. And the OECD's latest Direct Investments Regulatory Restrictiveness Index puts Australia as the 5th most restrictive nation, and that was even before the 2021 changes. All of this has combined to result in more transactions being notified to our regulator, FIRB, and therefore delays in receiving our foreign acquisition approvals. And this translates to delays in overall timetables. We're now regularly seeing approvals taking 3, 4, even up to 6 months from the date of notification. There are 2 real reasons for the increased number of notifications. The first is the FIRB guidance encourages a really broad range of voluntary notifications, so there are just more deals being notified. National security transactions are not just those in critical infrastructure industries like energy, water, telecommunications, etc. It also includes service providers to those industries and to governments who might only be providing sort of services as a minor part of its business. And secondly, I mentioned the call-in powers. Investors are just seeking to mitigate the risk of their transaction being called in by making a voluntary notification. I can give you some examples of this FIRB issue and how we've addressed this risk. In the first one, we acted for sellers of a traffic and vegetation management business to a US buyer. That business provided tree lopping and verge maintenance services to several local councils, which is not what you traditionally think of when you think of a target that impacts national security. Even though FIRB is really a buyer's issue, we as the sellers did some preliminary DD on whether we thought the transaction needed to be notified. And we thought that it technically fell within the scope of transactions which the regulator encourages buyers to notify. So we raised this early on in the piece with the buyer so they could form their own assessment. They agreed with our conclusion, and they also agreed to make a voluntary notification well before we even had a signed SPA. And this meant that we had the FIRB approval well in advance of our completion date, and there was no material impact on our overall transaction timeline. Another example where these foreign acquisition approvals have impacted transactions is we acted on a demerger, which involved the cross transfer of some share interests between our client and the counterparty. The other party was a foreign person, so their acquisition needed FIRB approval, but our acquisition didn't. There were some completion time pressures, so we asked the counterparty to do its due diligence on foreign acquisition requirements really early on so that we knew if we would need to make a notification, and they identified that they did. But even though this was identified really early on in the piece and an application was actually made before we signed an SPA, our client still didn't want to risk a delay to completion. So we came up with a creative structure whereby we completed the demerger by us acquiring their shares and them acquiring an option over our shares, which was automatically exercised when that FIRB approval was obtained. This meant that we got to complete in July that year. And we actually didn't end up getting our FIRB approval until the September. So it actually shaved off a full 2 months from the overall transaction timeline. Another area of DD that we have seen presenting some particular risks is privacy. This is an area that has and still continues to undergo significant reform. In Australia, we have the Privacy Act and some associated Australian privacy principles. And most businesses in Australia are broadly familiar with these by now. But the impact of the GDPR is less understood in Australian businesses. The GDPR, as many of you will know, is the equivalent of the Australian Privacy Act in the EU. And even though it can seem irrelevant to Australian businesses, it has really broad extraterritorial application, and it can impact Australian businesses that have an establishment in the EU, offer goods or services in the EU, or monitor the behaviour of or processes information of individuals in the EU. What this means is that if you're looking to acquire an Australian company that processes or controls or collects personal information, you really need to understand what personal information they hold and where they hold it. And then you need to assess whether their personal data handling practices comply with the Australian privacy principles and potentially the GDPR as well. In a share sale where you're inheriting the risks of the target company, you need to understand the likelihood and consequences of a privacy breach so you can mitigate the financial risk. This might be through price chips, indemnities, possibly backed with price holdbacks like escrows. But you also need to understand the reputational risks so you can determine whether you want to buy the business at all. And the fines can be pretty significant, particularly if you're breaching both the Australian privacy principles and the GDPR. For example, for a breach of the GDPR, the penalty can be up to 20 million euros or 4% of global revenue, whichever is higher. And there's also an ability for data subjects to seek compensation for damages. In addition, if the online privacy bill that was announced in 2021 in Australia is passed, the fine for a breach of the Australian privacy principles will be increased from 2.1 million to the greater of $10 million, 3 times the value of the benefit, or 10% of Australian annual turnover. So these can be some pretty significant fines. And as a buyer, you want to know about the risk up front, so you have time to negotiate protections, warranties, indemnities, price chips, and avoid arguments that blow out the timetable. Tied to privacy is obviously cybersecurity. We've all heard about personal information being the subject of a cyber attack and then being used for fraudulent purposes. So cybersecurity is another area that's becoming increasingly diligenced. And we expect this trend to continue as the tech boom continues, connectivity increases, businesses increasingly support working from home environments, and cloud-based document management systems continue to facilitate that. Cybersecurity is a particular issue for targets who maybe have experienced high growth over the short term because their internal operations may not have caught up to that risk, or those who've been highly acquisitive and maybe they haven't undertaken their own IT DD or properly integrated the various IT systems that they've inherited. Typically, we see a commercial due diligence alongside a legal due diligence. And that involves often a forensic due diligence undertaken by cybersecurity specialists who can understand the gaps and the pressure points of their cybersecurity profile, as well as insurance due diligence, so that you can understand how those cyber risks have already been mitigated, because it might be preferable to rely on that type of an insurance rather than a warranty claim against a seller under your share purchase agreement. Again, you need to know the weak spots up front, so you have time to close them before you complete or negotiate adequate protections. You don't want to find out at the 11th hour and either have time kill your deal or be forced into accepting a risk profile that you otherwise wouldn't, just to get a deal done. Another big issue that we're seeing in due diligence as digital transformation and the tech boom continues is in relation to intangible assets, and from my perspective, intellectual property. As Jerry mentioned, we'll hear from one of our panel members, Michael Masterson, on the challenges and risks of intangible assets from a commercial and technical perspective. But from the legal side, the focus is usually on 4 key areas. The first area is ownership and chain of title. Who actually created the IP and on what terms? If it was an employee, what does their employment agreement say about IP ownership? If it was a contractor, what does the contract for services say about IP ownership? Does the target actually own what you think it owns and what you think you're buying? The second is adequacy of protection. Has it registered all of its registrable interests? Are there opposition proceedings or prior art, which might mean that the interests are not enforceable? How much longer can those interests be protected? Who has the know-how? And have they written this down in a way that can be taught to other employees? And something which is often forgotten, what controls are in place to protect trade secrets? Who knows those 11 herbs and spices, and what confidentiality restrictions are they subject to? The third area is freedom to operate. Does the IP infringe the rights of a third party? Are you open to the risk of an IP claim against the target? And lastly, infringement. Is there a third party infringing the target's IP rights and undermining the commercial value that you think you're buying? I mentioned ownership and chain of title. Let me give you an example of just how important it can be in a due diligence. We acted a little while ago for a buyer of a company whose main assets was the rights to a particular software platform. We identified in due diligence some platform ownership issues, which are not ordinarily fatal. That's the point of due diligence. You identify the issues so you can fix it, get your deeds of assignment or whatever you need, or price in the risk. But in this case, the buyer felt that the seller was being deliberately misleading and didn't think it could build a good working relationship with them. So they ended up walking away from the deal. I also mentioned know-how. This is one that's often forgotten, but it's hugely important. If people don't know how the business operates, how can it be properly run? And you need to think about not just the key person risk, so who has the know-how, where's it written down, but also alignment of interests. So are the people who have the know-how within the business incentivized to stay in the business and continue adding value? Let me give you another example to show why that's important. We have a client, a company, who owns all of the relevant IP, but it relied on a particular process to be able to actually use that IP. That process was developed by an employee who was the only person who knew how to implement the process. And although that know-how was technically owned by the company because the employment agreement said so, the process had never actually been documented and no one else knew how to do it. So practically, the employee held all of the cards. The employee then used this fact during a critical time when the company was trying to execute a key contract as leverage to require a payment from the company. Now, if you're a buyer, you risk either holding up completion while you negotiate with that person and risk time killing your deal, or you could end up inheriting the bill. Better to know the risk up front so that it can be managed. There are also particular risks where the target uses a lot of open source software. And contrary to popular belief, open source software isn't software for which there's no proprietary rights. Rather, it's code that's made widely available for free under a standard form license. And these standard form licenses can have some pretty undesirable terms, There might be an obligation, for example, to make any changes that you make or derivative works freely available to the public. And that could be a huge issue where the target intends to commercialise that software. You might not be getting the value that you're paying for. There's also a greater risk that the software infringes third-party IP, because open source software doesn't have the same level of development controls as other types. And as a buyer, you want to know this now, so you can remove that infringement code and negotiate protections without having to delay a deal. The last category of due diligence I'd like to talk about relates to WII Insurance. I'm sure you all know the purpose of due diligence is to understand where the risk of a transaction lies and either remove it or apportion that risk appropriately between the buyer and the seller. We're now seeing a marked increase in WII Insurance as a way to shift that risk from the buyer and the seller onto an insurer. Why? Seller might want a clean exit, or maybe the seller has some credit risk and the buyer doesn't want to rely on a claim against them. Maybe the seller's made up of multiple parties, so there's just some logistical headaches with claiming against them. Or maybe management is being asked to give warranties, or the seller's being issued scrip in the buyer. So to avoid having to make a claim against a party with whom they want an ongoing relationship, they take out WII Insurance. It's a really great risk mitigation strategy, but WII Insurance is only as good as the due diligence that's done. And insurers will exclude from the scope of its policy any areas that it thinks have not been properly due diligenced. So the party that wears the gap risk is hugely incentivised to start due diligence early and do a detailed due diligence to ensure broad policy coverage. If the parties won't sign an SPA until the policy is incepted, WII Insurance and its associated due diligence is very much on the critical path. I mentioned that there are often exclusions to the policy, the WII policy. These often relate to things like title, environmental contamination, employment underpayments, privacy, pre-sale restructures, because these are often areas where the due diligence is either expensive or it's time consuming, so it's just not undertaken. There's also typical standard exclusions like fraud, knowledge of the deal team, forward-looking statements, fines and penalties, etc. And who wears the risk of these gaps in coverage is always hotly negotiated. There's lots of options. I'm sure you know there's a sole recourse policy. So the buyer wears all risk except in limited circumstances like fraud. Or maybe the seller will be on risk for losses up to the retention. So the sellers pay the first X amount before the policy then cuts in. Maybe the seller also provides top-up coverage, either just for certain categories of warranties like title or more broadly. And what that means is effectively once a claim has been made up to the policy limit, if there's anything left over, you can go against the sellers for it. Or maybe the seller takes on risk for all exclusions to the policy, which means the seller really wants to do some really detailed due diligence to make sure the policy is as broad as possible. It is a seller's market, so sole recourse is becoming a lot more common, but certainly they're not exclusive. We acted in one recent case where we were acting for the buyer in a competitive auction process, and there was significant pressure from the seller to accept a no recourse position and sign the deal without yet having a policy in place. So the WII due diligence would be undertaken after signing. If we as the buyer accepted that position, there would be no incentive on the seller to be as helpful as possible with getting due diligence undertaken and get as broad a coverage as possible because they had no risk. And there would also be no incentive on the insurer to give broad policy coverage because the deal had been signed and was happening whether or not WII was implemented. Another example we had was we acted for the seller in a deal that was not competitive, and there was significant pressure from the buyer to push all of the gap risk onto the sellers. We had to decide whether to take that risk before even having seen a draft of the insurance policy and being able to really understand the gaps and the risk that the sellers were agreeing to take on. There were some particular complexities because the seller shareholder base was really wide and had different risk appetites. Some were fine taking on all of the risk, others were, wanting a sole recourse position. And it was a real deal risk. So sellers ultimately accepted this position, but not without withholding for as long as we could and writing in some minimum policy coverage requirements into the share purchase agreement. So why does this all matter? Well, you need to decide early if you want due diligence, if you want WII insurance. And if you do, make sure that you engage with your insurance brokers as early as possible. They will review the SPA, give initial feedback on coverage, indicate a required scope of DD. Then you've got enough time to ensure that DD process can be properly undertaken to get as broad a coverage as possible. So if I could leave you with one key takeaway, it would be that time kills deals. And particularly in those 5 areas of due diligence that we've been through, the best way to mitigate your risk and avoid last-minute negotiations and potential deals falling over is to do due diligence, do it early, and do it well. And then, you and your advisors have time to put structures in place to mitigate your exposure without putting the whole deal at risk.
Elise, thank you. That was fantastic, very informative and very clearly presented. Thank you very much. It's my pleasure now to introduce you all to Michael and Tim, who will each then just present quickly on their background and their organisations and how they can help in this process. Michael Masterson is Managing Director for Australia and New Zealand for EverEdge Global. EverEdge is a global intangible asset advisory, valuation and corporate finance specialist business. EverEdge has helped many companies and continues to help companies unlock their competitive edge by identifying, valuing and monetizing their intangible assets. I've worked with and known Michael for a while, so I thought I'd look a little bit deeper than his LinkedIn profile to see if I could put something more interesting into this introduction than that. And I decided to search the internet to see what I could find about Michael Masterson. I hit a Google search that described Michael Masterson as not your typical businessman, and I thought that fitted very nicely. The Google snippet that I read said that he's a Peace Corps volunteer, which I didn't know. Sounds interesting. I discovered that he spends his spare time writing poetry, collecting fine art, and practicing Brazilian Jiu-Jitsu. It was at this point that I started to question how well I actually knew Michael and realized that I wasn't looking at the right person when I read that he doesn't like to talk about business. And sure enough, it was the wrong Michael Masterson. Unfortunately, I don't know whether Michael, that is about to speak to us, has a passion for jiu-jitsu. Hopefully he'll tell us, but I do know that he is indeed not your typical businessman. Michael started his career by building a team at Salesforce from 8 people to over 7,500 people over an 8-year period. He is passionate about creating sustainable and profitable growth companies and has focused in building a team of experts at EverEdge to help companies unlock their competitive edge through intangible assets, which, as he will no doubt tell you, account for well over 90% of company value on balance sheets today. Tim Strawn, on the other hand, has been at Ansarada for a while now. He's worked within the tech and innovation sector for nearly 20 years, with a keen focus on SaaS solutions that are targeted at the legal and broader professional services market. In recent years, Tim worked closely with firms and in-house legal teams across Asia Pacific to implement technology to power automation and document efficiency, as well as legal operations platforms for in-house legal teams. Tim is now heading the team driving the expansion of Ansarada's range of information governance solutions into the Asia and Oceania region. He's passionate about what ways technology can add value and make lives of professionals easier, which I wholeheartedly agree with. So I'm going to hand over to Michael and he'll give us a bit more background on EverEdge. And we'll then pass on to Tim and then we'll get into a few questions for the panel. And I really encourage you to share some insights that you have and questions that you may have for these experts. Wonderful opportunity. So over to you, Michael.
Thanks, Jerry. And I'm deeply regretting I didn't Google you before this. So I'm looking forward to the next time we present together. And I'm still wondering how Tim missed out somehow. So, but no, I just want to echo, Elise, look, great job. It's always great for us to obviously hear, Kane speak, and we think highly of you guys, obviously having worked together pretty closely on some really interesting stuff. As Jerry and Elise sort of talked about, intangible assets, the first thing I'm going to do is explain what do we call intangible assets? And words are really important. I know, talking to a whole bunch of legal counsel, you will know that better than I will. And look, we take the literal interpretation of the term intangible assets. And a good way to understand how we look at it, it's your secret sauce, your competitive edge, your unfair advantage, as accountants call it, goodwill. I know there's obviously a tendency for lawyers to call it IP. The challenge is when someone says to me, I have IP. Now, I'm apparently one of the world's leading strategists on IP. I actually don't know what you're talking about. And that's because it's just so analogous, because it means so many different things to different people. Fundamentally, what we bring intangible assets down to is that it's non-physical, it's intangible, you can't kick it with your toe, and it's an asset. Now, the word asset is two-sided. One is that it might not be of any value to you, or it could be. But the other part is that it might not be of value to you, but it could be to someone else. And this is the classic mistake we often see. But fundamentally, what intangible assets are really trying to explain are how you're going to generate a margin better than your competition, which means that you can then go on to achieve a market share. And more importantly, how you're going to stop, or realistically these days, slow down anyone who tries to compete or copy you. So this then leads into, obviously, due diligence. There's a capital event. You're either looking to raise money, so investors are wondering, you're looking to exit, so there's a potential buyer, or you're heading for an IPO. And that's typically where we find that moment of truth, which is, what is this asset worth to you as the buyer or to you as the seller? And depending on which side of the fence we're on, as Jerry knows, often we're on one side or the other, we take a particular perspective. And what we're trying to understand is, where is that real value? How do we explain that client's margin into a market share, in particular if they're ahead of where the market's at? And we've got innumerable examples from literally every product, service you can imagine, whether it's a startup all the way through to, probably one of our largest clients would be Comcast out of the US. Once you understand what that value is, and this is where Elise really talked about it, once we know what those assets are, and it goes beyond the legal registered rights, it goes into knowledge, know-how, trade secrets, confidential information, relationships. And ultimately, this all gets captured in the brand. And brand is often one of those assets that is often misunderstood and misvalued. And so that's certainly where we see one of the key risks. In fact, over half of the clients we deal with, and we've been around 14 years and dealt with over 2,500 clients, over half don't own their brand in a way they think they do. And if that ends up being your major capture point for all of the other intangible assets, that's a key risk. That's another one that we often see, Elise. And there's often a misunderstanding between what's called a word mark and a device mark. The word McDonald's versus the golden arches. And quite often we find people own the golden arches, yet it's not quite McDonald's yet. So in other words, they don't own the word mark. And that's really when we get into that risk piece. And then third is that all of this that gets captured in that value, how do we explain the value to an external party? Or more importantly, if you're acquiring the asset, how do we understand where the value is in us acquiring it, and what's the value to us? So valuation is highly contextual. But one thing that's really obvious is that risk is inverse to value. And to Elise's point, you want to get to this stuff really early. I'm talking not ideally months before, but years before. Some of these things can be very, very quickly fixed, like open source, in particular if you find the issue before the other party does. But some assets like brand and some of those other intangible assets can take years to rectify. And ultimately, it's about creating the narrative to explain to either the acquirer or the seller as to why it's worth that. And a bit like doing a building report for a house. If there's a risk, as Elise mentioned, this always comes back to price. So look, I hope that gives a very broad description. We fit in a very interesting vertical. We work very closely with accountants and obviously legal advisors. And really, as we've worked very closely with Kane, our job is often looking at those commercial and often how do we negotiate, in particular, whether we're on the buy side or the sell side, to translate that back to value. So Jerry, I hope that sort of covers it. I try to keep it very high level and not go too long.
And Michael, before I just hand over to Tim, I'm really conscious that we've got a group of lawyers that we're talking to. you and I have had this conversation about where does the distinction between what we do as a legal firm and what you do as intangible asset specialists sort of cross over. Is it worth you just touching on that very quickly, just to give context, as particularly in the context of due diligence? We've worked together on a couple of projects and it's very clear we do different things, but perhaps putting that into context in a due diligence exercise as to how that might work would be helpful to the audience.
Yeah, look, one of the things I'll touch on, because I think it's probably the most apparent example, is around friend operate. And friend operate is one of those really interesting concepts, as Elise touched on. And quite often, not so much with Kane, but we often find this with patent attorneys where they'll say, you know, you don't have friend operate. You're infringing on, say, a university. Now, legally, absolutely correct advice. Commercially, though, is the university ever going to find out? Is it going to become a major issue? Are they really going to sue you for damages? No. In our experience, they normally want attribution, and they're happy to often take pretty generous terms on the license because that's accreting value back to their brand. They're normally not commercially driven on the dollars. But so that context around a lot of those legal challenges, especially around due diligence issues, then leads into that commercial realm. And often, I think it'd be fair to say, and I hope you would agree, Jerry, we can say things that are often in that grey area. And more importantly, we can often find ways to get around particular issues that might not be 100% legally what you would say is the right advice. And we often say, look, the legal advice will be what Jerry says, and here is another perspective, which is how we could commercially tackle it. Now, I remember a piece of due diligence we did exactly around that, where legally the client had friend operate. It was a client we worked with on with Jerry on. However, the practical nature was that if that client's money had come in, they were now big enough to sue. So in other words, it went from legally, yes, you're correct now. However, the commercial implications of that cash coming in will mean that you are now actually big enough to sue. And as Jerry, I know that deal didn't go ahead, and it was probably the right thing to do.
Tim, would you give us an insight into Ansarada and your role, and again, just an overview as to how what you guys do helps with the due diligence process?
Sure. So for those who, actually probably a lot of you might have come across Ansarada in one way or another over the course of your careers. If you're already working as a general counsel, you might have been part of a due diligence exercise, a merger, a listing, an acquisition, or a sale. And as a part of that, it's highly likely that you encountered a virtual data room as part of that process. That's sort of Ansarada's bedrock. So we've been around for about 15 years. We're an Australian tech company, born and bred, now publicly listed, and now global. We've got offices all through Europe and London, and growing rapidly through North America and Asia. We're most known for providing the infrastructure that's used by advisors like Kane lawyers and their clients to facilitate those critical moments in a business's life cycle. So whether that's an acquisition, a divestment, listing on the stock exchange, a merger, in all of those critical moments where due diligence becomes part of the exercise, we've been there, hand in hand with both the advisor and the clients for quite a long time now. In more recent years, we've expanded more and more now to a suite of solutions that complement, I guess, the wider needs of companies across the spectrum of their governance, risk, and compliance needs, which all sits very nicely together in terms of the solutions we provide. When it comes to due diligence specifically, we're seeing more and more a company's profile in terms of their governance, risk, and compliance reporting and performance is extremely critical. And more ESG is a hot button topic, and a company's ability to demonstrate their ESG frameworks and reporting and history is becoming a really key consideration for investors and acquirers when they're looking at an acquisition. And we provide the solutions now to tie all of those moments together and support a customer. With what Elise was saying before, the punchy words, I like, time kills deals. We would like to think that the value we bring in these transactions and in these moments is infrastructure to facilitate the best of everyone's time and effort to make sure these things are handled in the most rigorous and automated and process-driven way. We're now positioned, quite comfortably as the leader, certainly the leading supplier out of Australia for these sorts of solutions to help companies sort of take control and ownership of their growth, with applications that drive efficiency, it minimises risk, and provides organisations with evidence of their best efforts to be good corporate citizens. And yeah, I guess that's probably a good sum up. My role within the business is helping them expand more aggressively. We're embedded in the Australian market and have been for many years. We're growing rapidly through Europe. And my key area of interest, where I've spent a lot of my career, is actually growing legal innovation technologies into the Asian market, particularly through Singapore and Japan. And that'll be where I'm spending a lot of time with Ansarada over the next couple of years.
That's great, Tim. Thank you. And just to bring that into context for everybody, we were asked to talk about sort of current themes in due diligence in Australia, and we felt very strongly that a current theme was that technology is playing a stronger and stronger part in actually doing due diligence. And it's not, we've moved a long way from the original role of Ansarada, which was how do we take a data room from a bunch of lever arch folders into an online space. It's come a long way, and the platform's fantastic to use. At least it links in neatly, I think, and I'll get Tim to comment on this in a second, but when we're talking about due diligence, how do you as a lawyer work with other advisors for people on due diligence? What are you seeing that's current in the way that things are working? I mean, for my own purpose, we did an IPO in the middle of COVID, and it was the most seamless exercise I've ever had on an IPO. Getting 40 people on a Zoom call was a lot easier than trying to find taxis to get 40 people into one room across 3 different jurisdictions. So, but what are you seeing in the way that people are working together at the moment around due diligence exercises and the use of technology and bringing in other experts?
Yeah, it's been a real game changer over the last few years. So we've gone from, literal physical due diligence, where you go to the offices and you trawl through files, to having an online environment. And then, over the last few years now, that's expanded not just to the actual doing of the due diligence, but the actual implementation of the deal, and an online environment for managing documents, sharing versions, keeping sort of document checklists and task lists up to date, allocating responsibilities, and actually executing the deal. So in my experience, gone are the days where you all file into a boardroom to sign the documents. It's all done electronically now, and everything is shared electronically. So,
and just to be clear, that sounds like, it sort of sounds self-evident. It sounds like everybody should know this, and it may well be that people on this call do, but we do lots of deals in the mid-market, particularly the lower end of mid-market, where we're still not seeing that actually being embraced as a way forward. Dropbox trumps everything through cost. But Tim, I mean, you guys are seeing the future on this. I mean, you guys went out of your way to make an acquisition to move beyond data rooms into workflow management and deal management with the Dockyard acquisition. Can you talk a bit about what drove you to do that and why that's relevant to what you're seeing in the market today?
Sure. I think there's probably two lenses we could take it towards this, and one is looking at it from an advisor's perspective and the way we work with advisors, and actually looking at the advisor's customers, who we also work with directly as well. It's interesting looking at Elisa's points there around gone are the days of things being done that way, but it is interesting. We did a pretty vast survey. I think we surveyed about 3,000 clients in August last year, approximately half of which were advisors and half of which were companies who are, the advisors' customers. And we asked them about the changing role of technology, what they value, what they don't, what they want to see within the process. And for the companies that we interviewed, 85% of them said that they would preference using advisors that can demonstrate innovation and technology in the way they deliver their service over an advisor that doesn't. But I would say still the vast majority of deals done today are done on email spreadsheets and VDRs, which are effectively a 20-year-old set of tools. So I think Ansarada identified there that was probably the benchmark, which is a pretty low benchmark for tech and innovation. So our growth as a business and investing in the merger with the Dockyard and bringing in their complex workflow and project management tools into our VDR, it's a step away from the idea of a VDR being something which is useful only at a certain point in a transaction, whether it's during RFI due diligence, post-merger integration, wherever it's brought in. And actually, the platform itself has a lot of use before and after that critical event. And so the life cycle and the time spent on the platform is where we dovetail into the value to the customer. And that is that from a company's perspective, readiness for one of these transactions can be simplified and made a lot easier by having the right infrastructure in place ahead of these events. Now, whether they're accruing that technology through an advisor or whether it's something they've gone out and investigated and established themselves, we don't mind either way. And we work directly with in-house teams as well as through advisors. But I think the role of technology is probably best summed up now in that the expectations of the market, especially through COVID, have really changed. Our tolerance for poor video connections and an availability has gone out the window. We do expect people to be available because they don't have to be there in person anymore. And the ability to collaborate in real time inside a platform that's facilitating a transaction, rather than waiting for emails and spreadsheets and version control and all of the risks that are inherent in the old way of doing it, we saw an opportunity to change that up. And so we're working closely with more and more advisors to sort of leverage those benefits in the way they conduct their transactions, which is good news for their customers.
It's great news for their customers. I think what it says to me is we're going to get less and less sleep with the more and more cross-border deals we do, Tim, if we're expected to be available all the time. But Michael, to Tim's point, he made the comment that there's a benefit of thinking ahead and using these platforms earlier in your business so that when you're ready to go, you're ready to go. I mean, that was similar to the point you were making, that it's not necessarily weeks or months ahead of doing a deal, but can be years. From a DD, again, I'm really conscious that we're talking about current themes in DD. A lot of what you talk about is going beyond what we as lawyers would look at in that DD process of doing this, the IP search or the know-how review, whatever it might be. You've talked to me till it's stuck in my brain about the change in value from way back when to now on listed company balance sheets, from tangibles to intangibles. How do you get your head around, from a DD perspective, where to go and look for these intangible value points and the things that are going to create real value in a deal?
Yeah, and I think, context is key to everything. And again, depending on which side, because we act on either the investor side or the acquirer side or the seller side. And certainly if we're on the seller side, it's about helping them understand where that value is to the buyer, and vice versa. If you're the buyer, what are we really buying? And, I think back to one particular example where we were dealing with a professional services firm. They'd been going for 30 years. They wanted to go through an exit event. They brought in an investment bank. The investment bank saw it essentially as a particular buyer. We got brought in at the 11th hour, and we quickly identified that one of the major assets this company had was the data set. And the investment bank kind of said, no, we disagree with you. We think that this will be a trade buyer. The trade buyers are going to have the same data or better data. We said, that's a very fair point. Now, the other thing that was distracting this client is that they'd been told they were going to get 4 times EBITDA, which normally for this particular industry being serviced, they would only get 1 to 2 times EBITDA. So 4 times was pretty good. What we did, though, is we identified that particular asset, that 30-year data set, was incredibly valuable to about 4 other industries. And they were sitting on the periphery of the insurance industry, which meant that it could be used for actuarial purposes. We identified those four industries, and that asset ended up selling for 32 times EBITDA. So an 8-fold increase in value, because that's what it was worth to the right buyer. And this is why, going back to Elisa's point, you want to identify these assets really early, and they're not normally captured in the balance sheet. And if they are, they're normally brought on at cost. And the one thing I can tell you is that cost pretty much has no correlation to value. It's either worth a lot less or a lot more. The P&L, depending on the stage of the business, if it's an early stage company, the P&L is not going to be reflective of value. And if it's a longer term company, it may be, or would hope to be. And they're definitely not on the fixed asset register. You're not buying the company for their desks, their chairs, their computers. And sure enough, they would go through an audit every year. So then what you say is, well, okay, if you take in a listed sense, to Jerry's point, the market cap, less the fixed assets, the debt, the cash, there's this big number. No one can normally give you a list of what makes up that number. To Elisa's point, who has access to that information, who has control of that? I mean, what's it individually worth? So really the process to going through some form of capital event or going into M&A, looking at particular acquiring assets, you really want to start early. And it's about understanding what is that asset of value to you, or vice versa, who is the right acquirer for that asset? Oops, I may have lost Jerry, or you've lost me.
Yeah.
No, got you. I got it.
I think we've lost Jerry, or I've shocked him with my answer.
He's done silence. Yeah.
I know. I never thought I'd be able to do that to Jerry. So here's a first.
All right. Let's see if we can get him back.
No worries. Elise, feel free to take over from Jerry.
Yeah,
Okay.
sure.
He's going to reconnect. Okay, Alice, you definitely go ahead, please.
10 seconds and then take over the reins.
I think that was part of your grand plan anyway. Did you disconnect his computer from the office?
You definitely kicked Jerry off, yeah.
I just think it's great that I finally silenced Jerry after the many years we've known
So you
each
finally
other.
got the last word, yeah.
I know. But it's so true what you say, Tim, just coming back to, we work a lot, obviously, with Ansarada, both with our advisory hat on, our corporate finance hat on, and I know I can tell you it's made our life a lot easier, especially the ability to get into one place and build out that data room. And in particular, if we're on the sell side, being able to, in particular, really highlight where that value is. And one of the tricks or the mistakes we often find is that people give away not just the what, but also the how. I can't tell you how many times we've gone into a data room and said to the client, no, you can't include that. You're giving way too much information. So yeah, it's one of those things.
It's an interesting thing too, because I've heard it said since I've been with Ansarada several times that a company's never as well presented as it is at that point of IPO, of merger, of acquisition, where you finally brought together all of the, as much as you can, IP, your contracts, your knowledge, your key documents, your personnel information. You finally got everything all in one place. And in many cases, it's the first time it's ever all been properly consolidated, audited, reviewed, and put into one place, which leads to that whole idea of making use of these sorts of tools for a longer period of time, because once all of that stuff is in one place, you're effectively, you never, what is it? You're never better dressed than your wedding day. You're never better presented, immediately post or pre one of these major moments in a company's life. So the ability to, after an acquisition, for example, to take that company through post-merger integration, knowing that you have already all of that audited, regulated, controlled and reviewed documentation that can easily turn into a successful project for embedding and bringing on a company, for example. The minds are expanding around the use and the role of technology and how it can add value beyond just that one moment within a transaction.
It reminds me of that famous saying by Drucker, what gets measured gets managed. And I think this is the real gap we're seeing around, the intangible assets, is that they're typically ignored until that moment. And that's where people, sometimes, unfortunately, I got some bad news where that asset may have leaked out already through, a key employee leaving or a process. And again, in our experience, 99% of it's just inadvertent leakages because no one ever told that person it was really valuable. In fact, often the company doesn't know it's really valuable until they're going through that process. So I agree with you. Just working out, the first thing we say to every client is just work out what those assets are, what's driving that margin, what's driving that market share. And then it just gets easier from that. But it's much easier, rather than trying to do it at once in the space of 2 to 3 months, to do that progressively over years. So welcome back, Jerry.
I think the challenge.
Oh, hi, Jerry.
Sorry,
Good to have you back,
Jerry. You missed the best bit of the webinar there, but yeah, please go.
Well, I understand that it's the best bit when I'm not around, so it works for everybody like that. So I am back, and I did pick up on the end of that conversation, and I think one of the things that the challenge with that, Michael, is that often, particularly with the intangible stuff, it's the creation of that happens way before anybody realizes it's actually valuable. And one of the things that I think we see a significant amount of in DD as a big issue is that concept of who were the original people who were involved in creating intangible assets, and were they actually signed up as employees, and did their employment contracts cover off assignment of IP provisions? And I've lost count of the number of deals where we've had to go and find people who've not been involved with companies for 10 or 15 years to get them to sign things up. Is there anything in your experience that can avoid that, apart from knowing what you're doing on day one and making sure you've got the right bits of paper in place?
Yeah, I think it just comes back to a pragmatic sense. I was running a workshop with a client this morning, and most companies start as 3 people working for beer and pizza. 3 people working for beer and pizza. They run out of beer and pizza, so one person leaves. New person joins with fresh beer and pizza. And this is where we start to get into chain of title issues, as Jerry says, because in fairness, at that point, they often, don't have someone like Jerry and Elise advising them. In fact, they probably have no one kind of advising them. They're just running as fast as they can. And a lot of this stuff sort of gets left by the wayside, and we've seen issues around them working with external contractors and not documenting that process. I remember one client in software on their board, mate, and significant shareholder was a very, very senior commercial lawyer at a very, very large law firm. And he said to us, no, we don't actually need an agreement with our IT provider because no one has those. And we're like, what? So there's a lot of misunderstanding around this. And then we'll often see little catch-alls on the supplier's website that just says, hey, we own everything. And then you get into, which overrules which. But all I would say is the sooner you start this process and the better prepared you are, the more likely you are to conclude not just a deal, but a deal where you're not having to discount the price because you found termites, in the basement or the roof space. And it's a bit like selling a house. The sooner you get it ready for sale, the more and you should have a business ready for sale at any moment, because you're never quite sure who's going to knock on your door and say, hey, we'd love your business.
Yeah. Hey, we've actually got a question from the audience, so I'm going to interrupt and move to that one. It's one for you, Elise. The question is, how is the WII insurance market looking today? What's the capacity in the market? What trends are we seeing in relation to premiums, terms, exclusions? And the last bit was, is this still an effective way to transfer risk, assuming DD is done early and done well? So somebody's been listening to you because they've quoted you back word for word. So do you want to take that one?
Yeah, sure. So the market for WII insurance at the moment has been really hot. So particularly towards the end of last year, it very much was an insurer's market, and they could pick and choose which deals they were going to insure. And we saw a lot of policy exclusions being sought because it was an insurer's market. So the other kind of upshot of that is an increase in policy premiums. I think a couple of years ago, the standard policy premium was about 1% of the coverage amount. Now it's getting up to the sort of 1.5%, 2% plus. So it's a very, it just goes to that point about due diligence. If you want WII insurance, the WII insurer has a lot of leverage to include policy exclusions already, because the market's favourable to them. So the better DD that you can do, the earlier you can do it, and the more you can get your brokers involved to smooth out that process, the easier it's going to be.
I think also, our experience when WII first came in, it was being sold quite broadly as sort of the panacea to not having any risk as a seller. Mm-hmm. And the reality is that WII is only as good as the DD that you do, and it becomes this sort of non-binary endgame. The more DD you do, the less you probably need to rely on WII insurance, because the better you understand what the risks are. And from a vendor's perspective, the more vendor DD you've done, you probably don't need to rely on WII insurance because you're prepared to carry the risk and save the premium. So, there is a bit of a dance that's still done around WII. I think we're seeing WII used more now for good transactional reasons. So circumstances where you've got a significantly broad vendor base that, as a buyer, if you suffer a warranty claim, trying to chase everybody down and get paid will just be a pain in the neck. You might use it to sort of offset some of the credit risk from that. You certainly, if you've got a gap in DD coverage as a buyer, an insurer is not going to give you coverage if you haven't been able to diligence something. So you're not going to get coverage that way. So that just puts it back on the seller. So I think the answer to the question is, it is a useful product in the right circumstances, but I think you need to work with your advisors to actually work out, do you have a deal where the circumstances apply that makes it worthwhile, or is it now too expensive? And to your point about Christmas, it wasn't just that it was an insurer's market. The insurers were so full for their year, they were just turning cover away. So there were some significant deals that were relying on WII as a deal mechanism to be able to close the deal that just had to be deferred because the insurers were just not willing to write any more business at the end of last year. They didn't have the capacity in their teams to do so. They didn't have an economic driver that made it worthwhile for them. So they just said no. So really good question. And again, one for you, Elise. When you come to doing due diligence today, how do you go about working with your clients and other advisors to actually agree what the scope should be? And what are the choices? Like, is it just one way of doing due diligence? Is it we get out a checklist and we just tick everything off? Or can you be a bit more tailored about how you approach it depending on the deal that you're looking at?
Yeah, look, frankly, it starts with a checklist, but it doesn't end with a checklist. To be able to create a really good scope of due diligence and actually test the things that need to be tested and kick the tires where it really matters, you really need to understand the target and its business. So, where are the risks likely to lie? Because a due diligence for a cybersecurity business is going to look very different to the DD for a petrol station business, because the nature of the risks of the business are going to be totally different. So starting point is understand the target, and then overlaid to that is understand the client and their risk appetite and their background. So what's the materiality threshold? How likely are they to care about particular types of issues? And that's relevant not just in doing the due diligence, but being able to properly advise on the recommendations arising out of that DD. So what's the most commercial course of action, taking into account the risk appetite of your client? It also makes things a lot more efficient and smooth, because if you can focus on the things that really matter, it's going to keep costs down, you're going to get it done quicker, and it's going to be a better outcome for everybody. So yeah, understanding the client, understanding the target, it's the biggest issue.
Yeah. Michael, for you, understanding the client, understanding the target, how do you go about using due diligence? And forgive me if you were talking about this when I was offline, but how do you use due diligence process to sort of uncover threats and opportunities that are sort of beyond what might be obvious at first blush? What do you guys sort of bring to bear?
Yeah, I think because we've often been brought in when things have gone wrong, I would say that's a fairly typical first engagement for us. So normally something's gone wrong. They've often gone to the lawyer, the accountant, and normally it's been, no, look, you really need Everidge to come in and see how you can fix it. We then use that knowledge, obviously, to our advantage. Again, depending whether we're on the buy side or the sell side. And if I take this from the buy side, we use this to push price down, because we're identifying things that normally have not been addressed, they've not been recognized, they've often been missed outside of Kane being their lawyers, because you guys are very, very good, because we've worked a lot with you, and you asking a lot of the right questions. You know, I suspect that maybe before you met us, some of the things that Elise talked about might not have all been there. And so, because eight years ago, when we started to talk about intangible assets, no one was really talking about this stuff. So there's a real lack of education and understanding. And, you know, at least this goes through to WII Insurance. We've done a lot with the insurers, helping them understand what are these assets. And, you know, I come back to it's an asset because it's worth something to someone, which often then leads into cybersecurity, which, you know, goes well beyond what everyone will probably think about cybersecurity. Most of the issues we deal with on cyber, the person who's lost the asset didn't even know that it was an asset to lose because it wasn't recognized as an asset within that organization. And as one of our clients, who's Jerry heard present, you know, was two people who came up with a formulation, and they only found out they had an issue because ASIO rang them and said, you're being attacked. Someone is trying to get your information. And it really comes back to understanding who else could those assets be worthwhile to. And again, to Elise's point, working out what your risk appetite is. Certain things we'll say to clients, look, this is a really low risk. Yeah, you could protect it, but at the end of the day, it's probably not worth the cost. Other things could be incredibly critical, like trade secrets. And our definition of a trade secret is, if that information gets out, it's game over for you as a business. The next category is confidential information. It gets out, it's not going to kill you, but it will certainly reduce your margin into your market share. And often this is around pricing information. So again, even the way you classify that information is really, really critical. Understand what's critical to your business, what's impactful in your business, and actually what's just generalist within your business. And I think government does this very, very well.
And to that point, I mean, due diligence is about somebody who doesn't really need to know, asking to see information that somebody doesn't really want to give. I mean, again, without sort of giving you another platform to sell, but I mean, that's one of the benefits of a platform like Ansarada, isn't it? I mean, you guys actually take time to think about the security aspect, which we then blow up because all of those things that you tell us are switched on for security, we say, no, but we've got to be able to print it and let people take it out of their office and all that. But how does that work from your perspective?
Yeah, it's a good point. I think who needs to know what at what point in the transaction is kind of the underlying theme that sits behind that, and the expertise with that is something that's really driven by the advisor in terms of what's material, what's critical to my client at this point. Then having the infrastructure that gives all parties the ability to regulate, report, audit, retract documents even after they've been downloaded out of a system and uploaded onto somebody else's computer. We have a unique capacity to actually explode a document off someone's computer even after it's been downloaded out of the data room. So, you know, those sorts of mechanisms and tech controls are really important, but the flavoring and the degree to which they need to be used is very different deal by deal, very different by the nature of what's being bought or sold or listed. And really that expertise and how that's driven is something we work hand in glove with the advisors with, because, you know, to Elise's point earlier about these processes might start with the checklist. So each firm might have its way of approaching a particular type of due diligence exercise, but it never ends with the checklist. I think a lot of these processes are scalable and repeatable up to a point. So having technology that enables a firm to kind of capture that essence, that secret sauce for how they approach these things, and make that information available through the transaction to the right people at the right time in the easiest way possible. Maybe a long-winded answer, but the reality is the more flexible and the more adaptable and more user-friendly the technology is, whether it's Ansarada or anything else, paired with the expertise provided with the advisor, that information sharing and collaboration should be something that the tech facilitates rather than obstructs.
It's interesting, your concept about that pairing of technology. We're using an AI learning platform at the moment to assist with our due diligence exercises. And again, I think when we introduced that to our lawyers, their first thought, well, for some of them was, this is great, I don't need to do any work anymore. And for others, they were wondering whether they needed to go and find another job.
There goes my job. Yeah.
Yeah. And the reality is, actually, the more we get to understand that platform and the better use we make of it, the more we realize that it can only spit out answers for stuff we teach it in the first place. And so our skills and expertise as lawyers, together with the use of the platform that creates greater efficiency in the way we go about doing the stuff we're good at, is actually delivering some really great outcomes for clients. But I'm sure as a technologist, you'd say that's always the case with technology. Technology never takes over. It's how you use it and how you apply it that creates the benefits.
It should be. And I think there's, I've done a lot of work outside of my time with Ansarada with AI and automation and those kinds of tech within the legal space, particularly around document automation, as another example, where we were trying to template in some industries, provide large firms with the capacity to have a simple Q&A to produce a complex legal precedent. And the senior lawyers would say no Q&A could ever create a document as complex and as clever as one that I would draft myself. But the reality was that they didn't start with a blank sheet of paper every time they drafted a precedent. They always had something to start with. So the need for that expertise is there, but the technology should only ever be seen as adding value and supporting and democratizing access to that expertise in a way. It's just making it more accessible and consumable, not offsetting it, not replacing it. It's about supercharging it, making it easier to get to.
Yeah, absolutely. I'm really conscious of time. Before we finish, though, I'd like to sort of go around all of you and say, if you had one takeaway for the people who are listening today, which on the whole are general counsels or lawyers in-house, what would it be around what's important in DD in the Australian marketplace for mid-market transactions at the moment? What's your sort of key learning for what's happening today? I'm going to be kind to Michael. I'm going to start with Elise, so apologies. But Elise, any thoughts?
I think it's just that point that I've been harping on about, that time kills deals. So, the earlier you can get onto your due diligence, the better the outcome's going to be, the more informed you're going to be when you're negotiating either as a buyer or a seller. So it's about, the whole purpose of due diligence is to be informed for your negotiations and to work out the pressure points so that you can mitigate them. So the earlier you can do that, the more time you've got to negotiate those points and mitigate your risks, the better.
Tim?
I'm going to steal Elise's answer and say time kills deals. And the sooner, as a business, you appreciate the benefits of having your infrastructure in place to be dressed for success for when that moment comes. It may not be something you're planning for. It might be something that knocks on the door. So about having all of your information in an accessible, regulated, auditable, retractable way, sooner rather than later, having your governance, risk and compliance processes visible and auditable and reportable, having your ESG profile really clear and articulate and able to be communicated. You wouldn't, run a marathon without preparing, and these sorts of transactions are quite like marathons, whether we like it or not. And these are just steps to getting the business fit and proper before you do something like this. So start early, time kills deals.
Michael, over to you.
I say this to every client: work out what your assets are. It's not your fixed assets. It's almost certainly not on your balance sheet. Your P&L is probably not reflective. Work out what those assets are, because that drives everything. It drives how long you're going to stay in the business. Who's the acquirer? Should you go and do M&A to bring additional assets in? And this is probably the number one. We've never worked with a client, and we work with many listed clients. No one can give us what I would call a fair and reasonable list of what those assets are. And so if you start there, wow, you can then start recording them in Ansarada. You can start having meaningful conversations with Elise and Jerry about what those assets are. How do you protect them? How do you make sure they don't escape before you even get to that DD event and potential capital event? So it's number one. You can't value what you don't know you have, and you can't protect what you don't know you have. So it really does come back to that first principles.
So I take all of that and I agree with it. I think the one thing I would add from a DD perspective, if you're being ready for DD yourself, all of those last couple of points make sense and are critical. The earlier you've prepared, the better your house looks by giving it a coat of paint and getting rid of the cobwebs and kicking the cat outside and all those sorts of things. If you're going to go and actually do DD on an opportunity, the thing for me is to really understand what's the commercial objective you're looking for and focus on that rather than get into the weeds on all sorts of other things. The reality is your advisors get paid to do a full and thorough exercise, but they will go off and do things that don't necessarily add value on your deal unless you've explained to them where the commercial focus is and got them aligned with you as to helping you identify and manage that risk. So talk to your advisors and get them focused with you on where you see value, and I think that adds a massive benefit to what you're trying to achieve. I am conscious of time. It's we've been going a good while. I would like to really thank Elise for your presentation and Michael and Tim for your insights and input. I hope everybody's enjoyed the conversation the way I have. I think when we come to an end, we'll lose this link for the participants as well. So thank you all. I look forward to being back in touch. And to everybody who's been watching us, thank you for your time. Please get in touch with any of us if you have any further questions.
Thank you, Jerry. Thank you very much. That was remarkably interesting, very useful indeed, I think. Huge thank you to Kane Lawyers, to you, Jerry, to Alice, Tim and Michael, and to our audience today. I hope to see you at another webinar shortly. So I'm going to close the link now and have a good day. Bye.